Got a copy of the Martin versus the Nova Scotia Workers' Compensation Board for chronic pain. It's a pretty good, it's a landmark case. It's case law. Goes in, it's pretty in depth. Finally, I am in a view of the view that this violation cannot be justified under Section 1 of the Charter. On one hand, budgetary considerations in and of themselves cannot justify violating a charter right. Well, they seem to be doing that all the time because they're cutting the injured worker off to make money. Although they may be relevant in determining the appropriate degree of deference to governmental choices based on non-financial issues by chronic pain claims, such as determining whether the pain is actually caused by a work-related accident and assessing the relevant degree of impairment in order to avoid fraudulent claims, is a pressing and substantial objective. However, it is obvious that the blanket exclusion of chronic pain from workers' compensation system does not minimally impair the rights of the chronic pain sufferers. The challenge provisions make no attempt whatsoever to determine who is generally suffering and needs compensation. They just blanketly say that. It's all bullshit. And who may be abusing the system. They ignore the very real needs of the many workers who are in fact impaired by chronic pain and whose condition is not appropriately remedied by 4-week functional restoration program. A last alleged objective of the legislation is to implement early medical intervention and return to work as an optimal treatment for chronic pain, assuming that this objective is pressing and substantial, and that the challenge provisions are rationally connected to it. However, they do not minimally repair the rights of the chronic pain sufferers. No evidence indicates that an automatic cutoff of benefits, regardless of the individual's needs, is necessary to achieve that goal. This is particularly true with respect to all moral benefits which would actually facilitate return to work, such as vocational rehabilitation, medical aid, and the rights to reemployment and accommodation. I thus conclude that the challenge provisions violate the Charter and should be struck down. The court has examined the jurisdiction of administrative tribunals to consider the constitutional validity of a provision of their enabling statute in Douglas College Supra, Cuddy, Chicks Supra, and Turalt Gadadori Supra. Together, in brackets, together, the trilogy. On each occasion, the court emphasized the strong reasons of principle as well as policy for allowing administrative tribunals to make such determinations and to refuse to imply a challenge provision found to violate the Constitution. First and most importantly, the Constitution is under Section 52(1) of the Constitution Act 1982, the supreme law of Canada, and any law that is inconsistent with the provisions of the Constitution is to extent of the inconsistency of no force or effect. The invalidity of a legislative provision inconsistent with the Charter does not arise from the fact of its being declared unconstitutional by a court, but from the operation of Section 52(1). Thus, in principle, such a provision is invalid from the moment it is enacted, and a judicial declaration to this effect is but one remedy against others to protect those whom it adversely affects. In that sense, by virtue of Section 52(1), the question of constitutional validity inheres in every legislative enactment. Courts may not apply invalid laws, and the same obligation applies to every level and branch of government, including the administrative organs of the state. Well, it states right in the Administrative Appeals Tribunal that they don't have to apply legal law. From the prince, okay, and obviously it cannot be the case that every government official has to consider and decide for herself that the constitutional validity of every provision she is called upon to apply. If, however, she is endowed with the power to consider questions of law relating to a provision, that power will normally extend to assessing the constitutional validity of that provision. This is because the consistency of a provision with the Constitution is a question of a law arising under that provision. It is indeed the most fundamental question of law one could conceive, as it will determine whether the enactment is in fact valid law, and thus whether it ought to be interpreted and applied as such or disregarded. From this principle of constitutional supremacy also flows as a practical corollary the idea that Canadians should be entitled to assert the rights and freedoms that the Constitution guarantees them in the most accessible forms available without the need for parallel proceedings before the court. Well, if you have to take them to court because of the Administrative Tribunals Act, that means you're being tried in parallel courts. Right there, you know. As LaForest J. stated in Interrogatory Supra at page 33, the power to interpret law is not one which the legislature has conferred lightly upon administrative tribunals. When a legislature chooses to do so, whether inexplicitly or by implication, the courts must assume that the administrative body at issue was intended to be an appropriate forum for resolution of complex legal issues, including the interpretation and application of the Charter. Thus, well as noted above, considerations concerning an administrative body's practical capacity to address such issues may be relevant in determining the scope of a tribunal's implicit authority to decide questions of law. They will generally not suffice on their own, but to rebut the presumption that arises from such authority, whether explicit or implied. Once the presumption has been found to apply, in my view, lower court cases which suggest otherwise, and it goes on. But these people refuse. If they're legally allowed to make decisions on the Charter, they say that they're not. So which is it? If they're not legally fit to make decisions, why do they even exist? I don't understand that. Because they're supposed to be versed in the legality of everything that's going on. I refrain from, however, from expressing any opinion as to the constitutionality of a provision that would place procedural barriers in the way of claimants seeking to assert their rights in a timely and effective manner. For instance, by removing charter jurisdiction from a tribunal without providing an effective alternative administrative route for charter claims. And that's what they did. Took away all our rights.